there were two structural changes since the law came into being on 13 January 2003. The first structural change was made in the year 2007 pursuant to a decision of the Honorable Supreme Court of India, where the writ petitioner actually challenged the structure of the Competition Commission, which was there in the Principal Act, that it must be headed by a judicial member but not an expert. After a contested hearing for nearly about 1.5 years, on 20th January 2005, Supreme Court disposed of that writ petition with an observation that besides the Honorable Supreme Court being the court of final appeal, there must be an appellate tribunal exclusively created to oversee the orders of the CCI as an exclusive specialized court of first appeal. The court of first appeal, popularly called COMPAT, continued from May of 2009 until 26th May 2017. And why I am saying until 26th May of 2017? Because in early 2017, the Government of India has introduced the Finance Act 2017, where, amongst other things, there was a proposal that the COMPAT, which was the exclusive specialized appellate jurisdiction to oversee the orders of the CCI, to be merged with the National Companies Law Appellate Tribunal. This proposal was approved at appropriate levels, and COMPAT ceased to exist with effect from 26th May of 2017, and the first Court of Appeal to oversee the orders of the CCI from 26th May 2017 had been transferred to NCLA. There is an amendment bill of Competition Act which has been placed before the Parliament on 5th of August 2022, and this bill proposes a further structural change in the competition regime of India. The proposal of this amendment bill is that the investigative arm of the Competition Act, that is the Office of the Director General, would be merged with the Competition Commission of India. Yes, how did the Commission and the appellate tribunals over the years had functioned is a very interesting historical fact which we can share. One, that with the introduction of a specialized exclusive COMPAT as the Court of First Appeal, since it had no other matters to be looked into, barring some few airports regulatory, economic regulatory act, etc., but the primary focus of COMPAT was to only oversee the competition appeals. The appeals were getting disposed of at a faster pace, and some of the orders of the COMPAT were also confirmed by the Supreme Court in the final appeals. So that was definitely a better point to be shared with all of you, as we were the practitioners appearing before the COMPAT on regular basis. With the merger of NCLAT and COMPAT, though the pace has definitely reduced on account of first that the NCLAT is overburdened with the company law matters, insolvency, bankruptcy code orders, it is overburdened. There is no denying the fact. And that has been aggravated by the COVID-19 pandemic, when the hearings started converted into online mode. And these all had resulted into slowing down the pace of the appeal considerably. However, from 1st August 2022, the NCLAT has started a physical hearing and the pace has picked up. It is in 2 months that the pace of the appeal tribunal has picked up considerably, which is a very, very positive sign. Now coming back to this merger of the Office of the DG with the CCI, it's an innovative suggestion, though it's still a bill. We are not yet sure as to what is going to happen finally, but this concept is something which is akin to the DG Competition European Commission, where the DG is extremely powerful in terms of the provisions of law, as it has got substantial power to adjudicate, investigate, and submit a finding with regard to any allegations of antitrust issues. So that proposal of the amendment bill is something which would actually enable the adjudicating authority and the investigative arm to merge. So we are yet to see as to how this merger of two different civil courts It's interesting to note that under the Competition Act, both the Office of the DG and the CCI are civil courts. So, how would two independent civil courts with independent mandate of investigation and inquiry will be able to work with an arm's length distance, ensuring fair and transparent adjudication and investigation process? We need to wait and watch. However, it may visit with substantial challenge as the investigation and adjudication sometimes may overlap, leading to some kind of a conflict between the parties who would be aggrieved and the parties who may not be requiring any further adjudication of their rights. Only one point of difference we would like to highlight here is that the DG Competition European Commission actually oversees the antitrust issues relating to the European Common Market, where the 28 members countries all have their national antitrust or the competition agencies independent of the European Union. However, it would not be identical as when we talk about India as an independent jurisdiction. So we have to wait and watch, and we have to see how things unfold. Until then, I think we always believe that the structural changes so far, which has been made until date between, say, January of 2003, until the unfolding of the DG subsuming into the CCI, we have to wait and watch.